time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney J. Bryan Nugen, founder of Nugen Law, and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. Hard to believe, but I have. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as estate and trust administration, guardianships, and planning for those with special needs. So today what I thought would be interesting to do is just go back to the basics to talk about the essentials of estate planning and things that are relevant for really everyone to have in place if at all possible, and to have a discussion about each of those items and hopefully to pique our listeners' interest and if they don't have their estate planning in place, I would encourage them to reach out to Nugen Law and see if we can't help them. Our phone number at the office is 260-925-3738, or you can send us an email at help@nugenlaw.com. That's NUGENLAW.com. So the essentials in estate planning. When I talk about what the essentials are, I'm referring generally to powers of attorney, advance directives, beneficiary designations, last wills and testament, and trusts. So, durable financial power of attorney. What is that? What form does it need to take, etc.? So durable financial power of attorney, I think, is something that people don't recognize is so essential for them to have in their estate planning, for them to have in place regardless of their age. We don't know when we'll be needing to use these. Once they're in place, most definitely they will be used. And oftentimes we're using these to avoid having a guardianship if that's possible. So what do we need to have a durable financial power of attorney? First of all, it needs to be in writing. It needs to be in writing. We're giving the authority for someone to act, and their title is attorney in fact. So the name of the document is durable financial power of attorney, and the attorney in fact is the person that you're designating that can make financial decisions on your behalf. When you make that durable financial power of attorney, when you make it, have it prepared, and you sign it, you need to be competent. And so competence for the world of estate planning is a little different than you might think. We're looking at the person. Do they understand who they are? Do they understand who it is that they're appointing to be able to make decisions on their behalf? Do they generally understand what's in that document and what that document means and what the person can do that's being appointed? Do they understand their estate and what assets that the person has control over during their lifetime? And then the POA needs to be notarized. So in writing, authority given to a person called the attorney in fact, need to be competent when you're signing it, and then your signature has to be notarized. So POAs are typically effective upon signing. They can be effective at a particular date or a specified event. I'm not a fan of using that type of power of attorney. I really like them to be effective upon signing. If they're effective when you become incompetent or incapacitated, we typically are required to have a doctor indicate that, in fact, the person that signed is incompetent. And that can cause a delay. So we want to be able to have immediate access to one's checking account, one's savings account, be able to immediately make decisions on your behalf. So if we need to wait for a doctor to declare you to be incompetent, there's a delay, there's a lag, and we want to avoid that. So I really prefer POAs to be effective immediately. They need to be durable, so still effective even if the maker becomes incompetent. So that durable language and the durable power of attorney means that even if someone is incompetent, that durable power of attorney is still in effect. Without that language, once someone becomes incompetent, if they become incompetent, the power of attorney is no longer effective. So we want it to be durable in nature. Next, we want to list powers of what that attorney in fact can do on your behalf. Those powers can be general or limited in nature. There are times we would have a limited power of attorney. We want someone to have access to just a checking account, just a savings account. But normally we have these in place that are very broad, and we want the person that we're appointing to be able to have access to all of our assets, to be able to buy and sell real estate on our behalf, able to make investment decisions for us, etc. Either we trust the person or we don't. If we trust the person to make all of those decisions, then we want it to be very broad. You can also appoint more than one person to be serving as your attorney in fact. So if I have 3 kids, I could name all 3 kids. And then I can have those children, those individuals that you've designated. It may be that they would all have to agree on decisions that are being made, or that they could act independent of one of the other. I frankly like them to be able to act independent of the other. It's important for us to be able to make decisions quickly and swiftly. And if you're nervous about one child acting and ignoring the other kids, perhaps that isn't the child to appoint as your attorney in fact. The powers of attorney are irrevocable. So if your child or I keep saying child, if the person that you've indicated as your attorney in fact has made decisions that you didn't like, you have the ability to revoke that appointment. So we want to have those powers of attorney in place to avoid guardianships if necessary. We want to avoid panic in emergency situations, and we want to avoid debts becoming delinquent, right? So we want those things in place sooner the better. Next, let's talk about advance directives. So when I'm talking about advance directives, generally, I'm talking about healthcare representative designation, and that needs to be in writing. We are designating in writing the authority to an individual, a representative, a designee, to make decisions about your health care if you're unable to make those decisions on your own behalf. You need to be competent when you are signing that healthcare representative designation, and you need to sign it in front of a witness. So those are some things that need to be in place for that healthcare representative designation. It commences when you, the maker of or the signer of that healthcare rep designation, are no longer able to make consent. You don't have the competency to make consent, to make decisions about your own healthcare. So unlike the power of attorney I was just mentioning, which is in effect ideally automatically when you sign or immediately when you sign, this healthcare rep designation only is in effect at such point when you can no longer make decisions for yourself. So you're always making decisions about your own well-being. You're in charge of your own destiny so long as you can be. Doctors, those in the healthcare profession, lawyers, we want our clients to be in charge of their own destiny so long as it makes sense for them to do so. And these are revocable as well. So if someone is not performing as you anticipated them to perform, you can revoke that appointment so that they're no longer in the decision-making, no longer have a decision-making capacity, and you can designate someone else to do it. And there is no liability on the part of the individual that you're appointing to be your designee, so long as they're acting in good faith. So if they're acting in bad faith and they're saying, do something to shorten mom's life, shorten dad's life, just so I can get to money faster and that can be demonstrated, then we may have some liability. But generally, if someone is acting in good faith and acting based upon what those healthcare professionals around the individual that signed that healthcare rep designation are advising, there would be no liability on on their part. So why do we want to have those healthcare rep designations? Why do we want to have those in place? So as I was saying with that durable financial power of attorney, we want to avoid a guardianship. If we haven't indicated who can make healthcare decisions for us, oftentimes people think incorrectly that my spouse can automatically make decisions for me, my children can automatically make decisions for me, but that isn't necessarily the case. We really want those healthcare rep designations to be in place and to be signed when you're competent and understand what you're signing, and the timing is good in that instance. We also want to avoid panic and emergency situations. So if we've done that well in advance, I always encourage my clients, please have a discussion with your children. Let them know what it is that you're wanting to have done if your health declines. Make sure that they understand how you would be making decisions for yourself if you were in that situation. It can be challenging and emotionally grueling for kids to have to make those calls when a parent hasn't said to them, this is what I want, this is the type of care that I'm looking for as my health declines. So what if my health is declining? How is it that I can let people know that I don't necessarily want to have my life extended indefinitely? If I'm in a persistent vegetative state, the effort to sustain my life is futile. What do I want to have done? So historically, we were using separate living will declarations, living wills. Now those are part of healthcare rep designations in Indiana, at least. But we still use living wills, especially for those clients outside of Indiana that don't have that combined with that healthcare rep designation. But generally, those living wills are letting the world know that if your health changes, if the effort to sustain your life is futile, do you want to continue receiving hydration and nutrition? Do you want to be kept alive indefinitely? Or is it that you're saying, if I'm actively passing, there's nothing more that the doctor can do? Do I want to receive hydration, nutrition, or is it okay to just let me go? Or do I want somebody else to make the decision for me? I express no opinion. Let them make the decision for me. So for these living wills to be effective, they have to be voluntary, in writing, signed in front of 2 disinterested witnesses, and those are the types of things that we're looking for in those living wills. So I'd like to say to my clients, okay, you have a living will. That's excellent. I applaud you for doing that. We need it. However, what's even more important is to have a discussion with the folks that you've appointed to be your decision maker for your healthcare as you age. It's all about guilt. If you haven't expressed to them what you do or don't want to have done, and they're flying blind, it can be very stressful and very emotional when the doctor is saying, we've done everything we can do, your dad is actively passing, what would you like to have done next? So if we can have a discussion with our loved ones, those decision makers around us in advance, before there's an emergency, before there's panic setting in or stress, it's always preferable. It's preferable because despite their having to make some tough decisions, they know in their heart this is what someone wanted. I use myself as an example. My grandmother, I was helping her at the end of her life, and I knew what she wanted, but it was my grandma, and it was, those were some emotional decisions to be made as her life was coming to an end. But I knew what she wanted, and I could rely on the discussions that we had had previously, and that helped me. And I always use that as an example with my clients. A living will is not a do not resuscitate order, a DNR order. Don't get that confused. Doctors will still make every attempt to cure your injury, your illness, disease, etc. So that is not a do not resuscitate whatsoever. So let's talk about next shifting to assets and transferring assets after you pass away. So how does that happen? In any number of ways, but let me go generally. Intestate succession with probate, last will and testament with probate, a beneficiary designation without probate, and then a trust without probate. So I've mentioned the word probate multiple times, and clients come in and they sheepishly say to me, what is probate? All right, I hear you're supposed to avoid probate. What is it? So probate is a process whereby we petition the court to open an estate, whether one has a will or doesn't have a will. We file notice in the newspaper, right? Someone's passed away, an estate has been opened, and we're telling the world, if this person owed you money, if you have a claim against their estate, you are welcome to file a claim in this estate. Estates are open typically a minimum of 6 months, oftentimes much longer, depending upon the assets that are in the estate, depending upon what it's like to try and liquidate assets in the estate, sell property. It may need to stay open for us to be able to file estate returns, etc. So minimum of 6 months, not hard for it to be 12 months or more. In probate, we're also going to be paying the debts of the deceased, address any litigation that's raised in the estate when it's opened, and then distribute remaining money to the beneficiaries, and we finally close the estate. The thing is that there are costs involved with probate. There's a publication expense, a filing fee with the court. But most notably, and this is coming from an attorney fees. You're going to incur a fair amount of attorney fees in going through the probate process. So we want to avoid that. It's also public. So if you have a nosy neighbor that wants to go to court and open your will and see what you said and how your money is going, they can do it. And then finally, time. So there is a length of time, 6 months, 12 months, however long it takes to go through the probate process. So let's talk about probate and intestate succession. So a person who passes away without a will, without a trust or beneficiary designation, and they have money in their name that isn't designated to go somewhere at the time that they pass, requires that we go through intestate succession. So I'll hear people say, I heard the state gets my money if I die without a will. Well, it would be very difficult for the state to actually receive your money if you pass without a will. There is a whole series of laws in the state that indicate where funds go, and that's called intestate succession. I think the takeaway, though, from intestate succession versus using a will or a trust is that your money doesn't necessarily all go to your spouse, and that's always shocking. People think that I'm married, so if I pass away, I don't want to do a will. If I pass away, my money automatically passes to my spouse, not to worry. Actually, that's not true. Some money could go to your spouse. Some money could go to your children. It also depends if you're on a first marriage, second marriage, third marriage, etc., and what children you had from each relationship. All of that can be affected if you, or can be put into place rather, if you don't have a will. So intestate succession makes the decision where the money goes if you don't have a will. So we want to avoid that if at all possible. So, how many people don't have a will? Well, only 40% of Americans have a last will and testament, right? So 76% of people believe having a last will and testament is important, but only 40% have them. Why is that? 50% of people say haven't gotten around to it. 22% believe that they don't have enough money to leave to anyone. They don't know how to do it, 6%, and then 6% think it's too expensive. Well, it's easy to make a will. 18 years or younger if you're a member of the armed forces or a merchant marine. Need to be competent when you're signing the will. The will needs to be in writing. There are rare exceptions, but the will needs to be in writing. And then you have to have 2 disinterested witnesses sign that writing. And when I say disinterested, it's someone that isn't standing to be a beneficiary under that will. They don't have any interest in it. So we want to have disinterested people sign. And so what does a will accomplish? At the core, a will tells the court how and to whom to distribute your assets through the probate process. So I'm going to designate my spouse as my personal representative, as my executor. I'm going to designate my child. I'm going to designate my best friend. I'm going to designate someone that I think will get my wishes or will implement my wishes that I've set forth within that will properly, will manage my assets appropriately while the estate is pending, and frankly, will follow through with it and get it done. It does, there is responsibility that's involved in serving as a personal representative, as an executor. And so we want to make sure that we have the right person appointed to do that. You control with that will how your assets are distributed. Is it going outright to a person, charity, church, another entity? Is it going at certain ages? So, for example, you're going to distribute money to your kids at ages 20, 30, 40. You determine how the money is distributed. Is the money going to be held in trust, a testamentary trust, for a period of time to pay for college of children, first home of children, weddings, whatever you can dream up, we can put in place. And then it's held in trust until a person gets their life on track. So let's say that we have a child that has a substance abuse issue or financial concerns. We could actually put language into that will that controls how the money is coming out to them to make sure that we aren't causing distress for them or funding a substance abuse concern that we have. Once it's put in writing, we can control that. And if one of your beneficiaries passes away, so you've designated your 4 kids to receive the money, if one of those children passes, where does the money go then? Does it go to their children, their grandchildren? Does it stay with your other 3 surviving children? Does it go to a charitable entity? You make that decision. If you have minor children, you also in your will would indicate who it is that you want to be a guardian for your children upon your passing. And so wills, the pros of wills: permits transfer of wealth at death as you want, not as the state decides. It's a structured procedure. The cons on having just a last will and testament is that probate is expensive and it's time consuming. It's also public. So as I say, if someone wants to be nosy and take a look at what you've got, they're able to do that. I want to briefly talk about beneficiary designations. So a beneficiary designation is I have a brokerage account and I want the money in that brokerage account to go to my children. So you place your children's names on the beneficiary designation. Bob, Sally, and Sue are going to receive the funds. What that so that's a positive, right? That's a positive in that we've indicated where the money's going to go, and we're not going to be going through the probate process. We're avoiding the expense of that. So that's definitely a pro. It reduces the estate cost at time of death. It's relatively quick disbursement of assets. I deliver a death certificate. When someone's passed, the bank cuts me a check. Here are the cons. It skips the planning in your will or trust, and people are surprised to hear that. So I've done this beautiful will, I've prepared a trust, and I have the money going to my children at certain ages, or to my grandkids. It's going to pay for their college, whatever it may be. If I use a beneficiary designation and the money is going directly to an individual, so the grandkid gets the money at 18 and they can spend it how they want to. Your will said they didn't get it until they were 25, or it was to be held in trust and pay for their college. But if I do a direct beneficiary designation, it goes automatically to them. That skips all that beautiful planning that you've done. Also, we need to make sure if your beneficiary has passed away, where does the money go next? Is it going to their children? Is it going to a charity? So when we're using those beneficiary designations, we have to be aware that it skips all of that planning, and we need to ask the question, if this person passes, where does the money go next? So on its face, a beneficiary designation is an excellent thing. It seems to be cheaper than doing a will. It seems to be cheaper than having a trust prepared, but we have to be very savvy when we're doing those and make sure it's most appropriate for you and what you want to get accomplished. So if those beneficiary designations wouldn't provide for any special treatment or protection for a minor, or if somebody has a disability, or for them to receive distributions over time, we have to be very sensitive to that. In Indiana and in other states as well, we can use something called a transfer on death deed, TOD deed. So we say, my home goes to my 3 children when I pass away, which sounds great. However, the children inherit the home. One child says, I want to keep the property. The next child says, I want to sell it. And the other one indicates, whatever you guys want to do, I'm fine with it. So the roof blows off. Who pays for the roof to go on now? I own it with my siblings. One sibling may be well-positioned. They can afford to put the roof on. Another child can't afford to do so. And the third child has just done work on their own home, and they're strapped for cash right now. But the roof needs to go on. You're in business with your siblings maintaining that real estate. So transfer on death deeds can work, but we have to really look at, is this what we want to do? Is it most appropriate for them to own real estate together? You're putting them in business together. Just a few years ago, I had a litigation that went on for 2-3 years trying to unravel a farm that had been given to family members. Of course, those family members have now passed, and now 2 of the 3 are in business with grandchildren and nieces and nephews, and it can be very, very challenging. So be very careful about using those transfer on death deeds. In certain instances, they're appropriate, but not always. Next, let's talk about trusts. There are all different types of trusts: revocable trusts, irrevocable trusts, pet trusts. Yep, for your animals, you can create a trust. Asset protection trusts, real estate trusts. So trusts are a giant category of instruments. I like to tell clients that a trust is really just a contract. You're telling the attorney that you're working with, you're coming in to Nugen Law, and you're saying, hey, Bryan, I want these things to be accomplished. I always tell my clients, don't worry about talking in legalese or trying to use language that you've read on the internet or what your neighbor was talking about. Just tell me what it is that you want to get accomplished. And it's my job then to reduce that to writing in a way that is going to be useful for you to get into place what you want to have done, and hopefully avoid going through the estate and administration process. So trusts need to be in writing and signed by you as the trust maker. The trust maker needs to be competent. We need to designate a trustee. You can think of the trustee as a manager of the trust. And then the trustee or the manager assigns accepting that designation. Normally, in most trusts, when we're talking about living trusts, revocable trusts, you are your own trustee. So you're the trust maker, you're your own trustee, and the beneficiary as well. So when you're creating a trust, you don't have to always give up control. There are times we want you to give up control, but in this instance, with a living trust, we're really just avoiding estate administration. We can do that. Then within the trust, within that contract that you're writing, we want to describe who or what benefits from trust. Both now and at the time of your passing. So during your lifetime, generally, you're going to be the beneficiary of that trust. Any assets that are in there, any income that's produced, that's benefiting you. So those are the things that we want to have in place. And just like with the beneficiary designations I was speaking about earlier, the trust does that, but with so much more depth. I can say the money goes out to my grandchildren, but that money goes out over time. I can say that if a grandchild or a child happens to be a special needs child now or in the future, we're going to drop that down into a subtrust that's protected for them. So, pros of doing trusts: avoid probate at time of death, privately handled, no nosy neighbors going to court to look at what you've done. There's no publication, there's no court or judge involved. It's less expensive at the time of your death. No attorney fees, no court costs, no publication costs. We can put in controls on distributions not permitted by simple beneficiary designations. And so those are really the pros. Cons: it does cost a little bit more typically to do that than to do a last will and testament. However, the savings are manyfold over what you would if you were required to go through the estate administration probate process. So, what are the takeaways? More than 50% of Americans have talked about estate planning. They just don't talk about estate planning as they should. We want to accomplish estate planning through use of wills, sometimes beneficiary designations or trusts, and we use what estate planning technique is right for you. That's my purpose as an attorney, is to speak with you and determine what's the best type of estate planning for you as a Nugen Law client. Well, looks like we're coming to an end of today's show. If someone would like to speak with me personally or another attorney at Nugen Law, I would encourage you to call 260-925-3738 or email us at help@nugenlaw.com. Thank you for listening to Life Care Planning with Nugen Law. I look forward to next weekend on WOWO, Saturday at 9 a.m. for Life Care Planning with Nugen Law. Enjoy, everybody.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to nugenlaw.com or email help@nugenlaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.